Hello, welcome to this week's Private Funds Update. I'm Sandra from SmartEsq, and today is Thursday, June 18th, 2026. Let's dive in. We begin with a monumental ruling from the Supreme Court that effectively shields registered funds and their boards from a key avenue of private litigation. The court ruled that Section 47(b) of the Investment Company Act does not create an implied private right of action for the rescission of contracts. To understand the substance here, Section 47(b) provides that contracts made in violation of the ICA are unenforceable, and courts may not deny rescission once a contract has been carried out. For years, plaintiffs' attorneys have weaponized this language, arguing that it gives shareholders an implied right to sue fund managers directly, to void advisory agreements and claw back millions in fees. The Supreme Court has firmly shut that door. The court concluded that Section 47(b) provides a remedy but not a standalone cause of action, and it is not the judiciary's role to read one into the statute. For registered funds and their sponsors, this is a massive sigh of relief. It ensures that enforcing the ICA remains the primary domain of the SEC, dramatically lowering your exposure to opportunistic class action litigation. Shifting to compliance, the SEC's Division of Examinations has published a critical new risk alert, focusing on investment advisors' obligations regarding economic conflicts of interest. Examiners are flagging persistent deficiencies in how firms handle revenue sharing, compensation arrangements, and undisclosed fees. The alert explicitly calls out scenarios where advisors incentivize personnel to steer clients toward higher-cost share classes, or where firms use proprietary products without adequately disclosing the underlying financial benefits received by the advisor or its affiliates. The takeaway for chief compliance officers is urgent. The division is actively hunting for discrepancies between what you practice and what you preach. You need to audit your Form ADV Part 2A, other disclosure documents, and your internal metrics to ensure that every economic incentive is not only explicitly disclosed to your clients, but actively mitigated in your compliance manual. In the derivatives space, the CFTC is stepping in to regulate the explosive growth of prediction markets. The agency has proposed a comprehensive new framework for regulating what it calls event contracts. As retail and institutional capital floods into platforms like Kalshi and Polymarket, the CFTC is drawing a line on contracts deemed contrary to the public interest. The proposed rule authorizes the CFTC to prohibit transactions that involve one of 5 enumerated activities: unlawful activity, terrorism, assassination, war, or gaming, if they are determined to be contrary to public interest. The substance of this proposal is about defining the boundaries of legal hedging versus unpoliced gambling. It replaces the CFTC's old all-or-nothing approach with calibrated case-by-case scrutiny. For proprietary trading firms and institutional investors eyeing this nascent asset class, the regulatory guardrails are beginning to take shape. Finally, looking north, Canada is making a significant push to strengthen its position in artificial intelligence. Prime Minister Mark Carney has launched AI for All, Canada's new national artificial intelligence strategy. Rather than focusing solely on restriction, the Carney administration's initiative aims to aggressively accelerate enterprise adoption, while implementing a predictable regulatory framework. For private equity and venture capital funds, this strategy signals a more supportive environment. The strategy includes investments in sovereign computing infrastructure, tax incentives, and strategic international partnerships to build resilience. If your fund targets North American technology, Canada just signaled that it is open for business, offering a highly incentivized environment that stands in stark contrast to the heavier regulatory headwinds currently seen in the European Union. That's your briefing for this week. You can learn more about these topics from me on the SmartEsq platform. If you are curious about the services we offer, please visit www.smartesk.ai.